So does anyone have any questions from the last exercise? We did the software development one.
I actually do have a doubt with the uh, with part 1 of the problem, part 4 also, I suppose. So mostly because making a testing clause in the blind without having a sense of what the product is seems, well, essentially it means that I have to add some hypotheticals that are not part of the question, right?
You have to leave a placeholder for it.
Okay.
That you'll have to do in many contracts when you draft. Sometimes you will not know what to write and what not to because you don't have instructions from the client. But yet you may be able to put it in a way that that a client knows ki, okay, I must fill this up. Okay, so that can happen. In that case, it makes sense, rather than not doing anything, to communicate to a client also, it makes sense that let's put it like this and let's put this placeholder. So then it becomes easier. We were doing the software development agreement or the software licensing agreement. 1 second. We completed the test and evaluation agreement. Then we did this one, no? Software development agreement. Okay, let's see. Chandra Mohan, did you experience more comfort this time while drafting? We shared the test and evaluation agreement with you for reference. Did you all have the time to go through that template? The test and evaluation agreement? I know you did the exercise prior to that week, but did that sort of add value for you? Everything I'm asking.
Yes. After going through it, we could make out the mistakes that we made.
You could?
Yeah.
Okay. Who is speaking? Jitika. Okay. Got it. And also note that many agreements are drafted, like they can be drafted in multiple ways. So it's not necessary that there may or may not have been a mistake, but we gave you 5 clauses to work on. But when you see the whole agreement, I think the whole picture of it may have gotten clearer for you. Right?
True.
Okay, so I'm going to share from my screen. Just hang on. So there are people, this is a combined class because this contract is common to people from cyber law, contract drafting and IPR. There are some parts which are common, that's why this is combined. So I think I should probably give feedback on drafts from multiple courses so people can all have an experience of this. Okay, so let's revisit the problem. It was about drafting a software development agreement. I'm sharing my screen with you. Can you see the screen? Is my screen visible? Okay.
Yes.
So AYZ Limited, a company incorporated in India, wants to get a software developed for their website. Okay. Now they come across this firm which develops the required software and asks you to draft certain clauses. 40% money needs to be paid in advance and the balance after testing and meeting milestones. Draft a suitable clause. Draft an IP clause saying that AYZ owns all rights to software developed by ENS firm. And draft a variation of the same where AYZ only has a license and ENS firm owns the copyright. ENS firm is the developer. So 2 versions of it are asked. Next is that AYZ Limited intends to test the software for a 3-month period before making payment, whether for purchasing or for a license. Draft a suitable software testing clause. Provide a mechanism to fix errors in a time-bound manner. Hence, firm warrants that all the IP developed does not infringe third-party rights. Draft a suitable clause with respect to the above mentioned information. So, whose solution do you want us to go through? We have Praful, Jitika. Okay, so I'll just open Jitika's. Okay, Jitika, what is the date of execution of this agreement?
The date wasn't mentioned, so at the end I have
The date that they will write at the bottom, right?
yeah.
Okay. It's great that you drafted the full contract. In case, so you can draft only the 5 clauses to start with here, or draft the full contract. If you are putting the whole title and everything, then it makes sense to leave place for stamp duty, because you've created the signature page also with the date and the names of the parties. So it makes sense that you leave some space so that you can print this on stamp paper, because this agreement will need to be stamped, right?
Okay.
Okay, so party A agrees to pay party B 40% on the date of execution. What is the amount?
The amount wasn't mentioned.
Yeah. So these are the things that you have to say, no? You have to create a provision for it. Every time you get a contract, this is the biggest problems you will face. Clients agree, and the other side agree on the commercials, but they may not, or they sometimes don't agree on the exact number, and they are still negotiating. So they don't share that detail with you. Okay. They just keep a blob for that. Or okay, so you will not be able to write these commercials. These commercials a lot of times go in last. Wherever there are numbers, you will notice they go in last. Last in the sense that you will make everything and then you will get the commercial just before signing to put the numbers. Okay, so that can happen a lot of times. So what I suggest you do is that keep a placeholder for it. You understood? So you create that X amount, dash amount shall be payable for development of the software. And that you can define, you can call it in brackets consideration amount. Then you can say 40% of the consideration amount will be payable on the date of execution. Then you need to say, then this was milestone based, right?
Yes.
So milestone, is there a place where you have incorporated the possibility of including milestones?
No.
One second.
That
So you've written successful testing, and within 2 months of testing period, I think there were more milestones here. Hang on. Yeah. So in parts with successful testing and such other milestones are met. This whole piece is there, right?
true.
Can you see this?
Yeah.
So we needed to say one is testing and the second is by when it's met. Just 1 second. Yeah. Yeah. So let me see if someone else has addressed this part of it. Praful, have you addressed this, or Saroj, had you addressed this? Let me see. Praful is not in this one. Okay, so Praful has written, I'm just going through different drafts so we can see how different people are doing it. 40% at the time of execution, 30% payable at the time of delivery, and balance 30% after successful testing for 3 months. Okay, excluding the time required to fix the errors. So you see this place here, that this is the way you can put in blanks. You see box brackets. with an asterisk. This is the way you can do it, okay? And then Praful has put a date over here. You can put a box bracket or a date, that's fine. Every agreement will have a date even if it's not provided to you, right? You will need to write that. Okay, so milestones he has also not put. And the duty to correct errors is not there. So payment is conditional, right? On the successful testing has been written, but there is no corresponding duty to rectify the errors discovered in testing. Only then the money is payable. Then the testing is determined to be successful, right? Otherwise, it is not successful, and you don't want a dispute on there being a question of whether it's successful or not. So that time period and the duty to rectify errors will be written. He has said we are excluding the time required to fix the errors, but where is the duty written, right? Another way of doing it is that he could write it in another place, in a separate column on obligations of the developer. But then he will have to connect that to payment. Either in the payment clause or in the obligations clause, the two clauses will have to be connected, saying that if that doesn't happen, balance is not paid. And what you can think of is that 40% was paid upfront. Now, why is 30% more? Now, the only other milestone we're looking at is delivery and then testing. Why not something else? Can there be something else, other stage in software? Can it be broken down into parts and components that can be started and used? So that will depend from industry to industry. In certain cases, let's say you want to get an app made. Now the app may have features which start from level 1 features to level version 3 ka features, and version 3 is the final launch version. So you could have key module 1 of this is complete. That is when I make 10% payment. Module 2 is complete, then I make another 10%. You can make it like that also. Just giving examples. Let me try someone else's. Saroj. Now see, Saroj has written about the milestones, okay? And he has even defined what's a milestone. Development is a milestone, testing, debugging, and release. These are the milestones. And he has made something called testing and defect liability period is 3 months, okay? Now you can similarly define more milestones. Now he has put in, see, this is like a construction contract style. EPC contracts have this, that an amount equal to 10% of contract value will be on hold with the client towards the defect liability. Client will release the amount after completion of defect liability period without interest. Defect liability period is 3 months from delivery of software. So his payment structure is a bit different. Some of you have done 40, 30, 30. He has done 40, 60. On completion of each milestone. His milestones are not clear because sequence of milestones is not clear. He has written 60% will be paid by client to vendor in equal amount on completion of each milestone. But he needed to write equally or pro rata or something, because it seems to me there are 1, 2, 3, and 4 milestones, and 10% of the value was to be on hold. That is what it seems to me. Now 60% is paid, then how is that 60% divided amongst these different milestones? That is something he had to explain. Okay. So are you seeing how to actually plug any gaps or loopholes in drafting? Now I want to know this, whether variations have been made. Okay. All copyrights will be under the ownership of the client. He may further use his right to use the product within any of its organizational setup. variation, the software will be delivered to the client under the perpetual licensing agreement. Vendor will retain the copyright with them. Okay. So, so the typical way we draft it, if a client has to get it, is by writing that all rights, all intellectual property rights are assigned immediately upon creation to the client, who is free to use the software in whichever manner he intends to use it. Here it's written that copyright will be given to the ownership of the client, but he may use his right to use the product within its organizational setup. Now, if I read the first line, then if I have the copyright, I can use it whichever way I want as a client. So the second line appears to limit the use of it, but it will not hold good if a court is to interpret it. So typically they will say that it will be assigned to the ownership of the client upon creation immediately, and the client is free to use it in whichever way they want. In case you're doing a licensing, then the client will want to know that what kind of a license is there. So it will be delivered to the client under the perpetual. Now they made this perpetual, which is great. But software licensing is seldom perpetual unless there is a payment. Here there is a payment. Still there are terms and conditions, right? That it is licensed for 2 years. This is the version that is licensed. If there are upgrades, then there will not be. So usually it could just have been that this software will be licensed to the client who can use it for his own purpose. The other thing that's needed to be known is whether the vendor can license this software on his own to other people. Okay, whether the vendor is free to license it to others within the same territory, within the same business, all of that. These are very important terms. So you need to write whether this is going to be an exclusive or a non-exclusive license that is given by the vendor. Are you able to follow? That's why we had inserted this clause so that both variations can be seen. One variation where the developer assigns all rights to the client, and the other where the developer holds it. Where the developer holds the copyright, he's in a stronger position because he can build a company out of it, from building and improvising that software and adding different kinds of features and modules to it. So it can license this to different kinds of clients based on their needs. It could allow customizations to happen. Developer will retain all these rights. But when I transfer the right to the client, I don't have any of these rights. Okay. So where the license is there, in that version, you could also say that can the client modify the software or not? All those things can be written. Now this is important. We wrote in clause C, provide a mechanism to fix errors in a time-bound manner in case of failure. So let's see if anybody has done that. So here, this is Saroj. He has written a 7-day liability, and he said that he will notify the client for vendor for errors and its code. And on receiving the notification, vendor will arrange to rectify the same. So this is a valid rectification clause, failing which the client may initiate lawful proceedings. It's not clear for what though. Will he initiate proceedings for? So let's say the developer fails to fix the error. Then the client initiates proceedings. For what? For the duty to fix the error. Is it just that? There needs to be another consequence, because the duty to fix the error, how do you enforce it? You enforce it by something called specific performance, where the court says that you've been paid for it, fix it. But there's always required to be another alternative. In most of these cases, you will want another alternative to this. What if the developer doesn't want to fix this? Or is unable to fix it? What is the consequence? Should he repay the 40% advance? That's the question. Should he repay the 40% advance? Is the balance amount anymore not payable because the developer has failed to fix this? Is the agreement now terminated? So that consequence of failing to rectify must be specified in this clause. Right? Let's see someone else who's made this. Let's see Purvi Maharesh's. Okay, my computer is stuck on this. Mandeep, let's see yours. So, some of you have not done the variation draft in the ownership. The right of ownership shall accrue to AYZ unless otherwise agreed in agreement and subject to any limitations laid down. So this is making it vague. Yeah. You said that it shall accrue to AYZ unless otherwise agreed. Now this is the very agreement where you want to specify yes or no, that the person retains the right or not. So you might want to just finalize it that this will be with this person, because we are not leaving room for exceptions here. Then why subject to any limitations laid down by agreements or mandatory law? We are actually designing that this is how it should be there. So we're going to determine it that the rights is with this person. Okay, we should not leave open-ended clauses. It makes the agreement very vague. At the time of enforcement, also this will become a problem. You're leaving holes here that they may argue subsequent conversations and writings and conduct as evidence that, oh no, this was written in our agreement, but this is how we have been behaving. Or here they may start using statutory provisions to argue something else.
कौन है निजर काज कौन
The variation version of this was in draft by Amandeep. So you need to draft both, okay? Then where is the mechanism to correct errors? So here you have said within this period of 6 months errors will be rectified. But they will need a very robust process, right? It's very generic. Now when you have these software related agreements, usually you will have tighter procedures. Then you can make your own process. You can say, and errors are not always given all at once. So they may have a weekly process or a monthly process, or they might give notification of errors on an as-is basis. So they will need to know that, okay, there can be a single point of contact for each side. And whenever there are errors, this single point of contact will be notified. These errors must be fixed within the next month. And every month we will do this such that within 3 months we will have the final product ready. And the client also may not have the ability to give request changes after this 3-month period. You can say that within 1 month the client has to figure out all the errors after testing and give it to the developer. Then the developer has to fix it again within a period of 1 month. That kind of system. Hence, firm warrants that all IP developed by the firm does not infringe third-party rights. So draft a clause with respect to this, and one clause stating that what will be the consequence if we warrant. So let's see this. That neither developer nor the completed system will infringe any patent, trademark. What is the meaning of your system? See, system was a capitalized term which I saw here. Completed system. But what is system here? What does it mean? Amandeep, you're also online, right? Yeah. So what is a completed system? You need to define that this is what you mean by system. I'm not able to find it. I don't think you've done it. Okay, so use a capitalized term like this if it is defined, then it will have a very specific meaning and your contract will be tightly worded. But if you don't define it, then it won't work, okay? In case you have an exercise where you need to draft certain extra clauses to make sure that your clauses make sense, then you can add those above, okay? Like I didn't ask you to create a definitions clause, but here you will need one so that your word system has a meaning. So you can do it that way then. Nor the completed system will infringe any patent, copyright, trademark or other proprietary right of any third party, and will not use any trademarks. This is perfect. Now what are the consequences? Let's say. To the extent permitted by law, developer agrees to indemnify and hold harmless AYZ, its directors, okay, from any and all claims, losses, and costs incurred by any AYZ Limited indemnified party. All these are, see here you have defined it. These are the indemnified parties. As a result of the developer's breach of this agreement due to violation of third party intellectual property or proprietary rights. Okay, great. So this is a valid indemnity clause for breach of third party rights. In all IP situations, this clause is very, very important. Let me see here. Vendor will indemnify the client for any kind of intellectual property infringement. If indemnity turns out to be false, the vendor will be liable for entire coverage of damage claim from client by third party for infringement. This is great. This is perfectly suited for how the client would want it. The vendor would hate this version, but this is perfect for how a client would want the indemnity. Okay, any questions so far? How many of you are attending this for the first time, this class today? Okay, all of you have attended this class before. Great. So any questions so far? So one thing we will do is that for all the exercises that you have completed so far, we will upload the templates. We'll upload the templates and let you know that this is done. We did that for the software testing, test and evaluation license agreement. We'll also do it for this, and we'll do it for the non-disclosure agreement, which some of you have drafted. And the next agreement I'm giving is a music licensing agreement. Okay. But I think I want to just give a feedback here that I think as you are writing more clauses now, things are improving. Chandramohan, you haven't written once also so far. You need to start writing. Okay, if you see everyone is writing in plain English and there are so many variations of clauses. Just put your pen on paper and just start typing. Yeah? Try to communicate the meaning of what is there in the assignment. It will come. You will get better with it. Trust me. Okay.
Abhay there?
Yes.
I just had that the last clause that we discussed, if the indemnity turns out to be false. Can you just explain to me what the implication of that would be? And can we go back to that clause once again to read it?
The question was that what will be the implication in case the indemnity turns out, in case the warranty that no third party IP is infringed, that turns out to be false. Okay.
I think we discussed it. Yeah.
This one. This is the one you want?
Right. And we discussed the clause which was related to that, which was drafted in relation to
the warranty is that all IP that we have given as a developer is owned by us or developed by us, and we are not infringing any third party rights when we do this. If you have developers who use other IP, there are certain frameworks developers use which allow them to use that framework to develop software, more advanced software. Okay, so they are basic frameworks they use. So then you can also say that all IP is ours, or we have the license to use tools to create this software. Okay. Now, in case we are in violation of any of that, if our warranty turns out to be false, certain consequences are possible. One is termination of the agreement. Second is that indemnity is going to be there. Okay. Indemnity in the sense that because if the warranty is false, people may not go after the developer. They will go after the user. That you are now using the software. This has our IP. Developer will be out of the picture. So that's when that person will come back to the developer and say that, listen, this is what your warranty was. It has turned out to be false. So there can be additions in this clause saying that when we are sued, in case we are sued by third party violations, we will add you to as a party to the suit, and you will be defending us, and you will be paying all the costs of the suit, that of the legal proceeding. That part you can add. Okay?
Right. Got it. Thanks.
So are you all experiencing that there are two things our intention is for you to experience. One is that your comfort and ease with respect to typing clauses should increase. And second is your insight or knowledge about different kinds of contracts will develop with this. Okay, so these are the two main aspects we would want you to derive from this course. So you get comfortable with drafting different kinds of contracts. You also start noticing that these are unique aspects of this industry. So, for example, Saroj did something brilliant. He said that 10% of the whole contract value will be withheld until everything is finalized. That was great. But one thing we missed out on, Saroj, this I was saying before you joined in, I think, into the class, was that the milestones were defined, but it was written that 60% will be payable after the completion of the milestones. But which milestone, how much will be payable? Because there were 4 milestones. So I would
equal. I have said the equal. It will be.
equal wasn't there. Let me just check. Okay.
Yeah.
So 40% is before. Now, how much will be payable afterwards? Because 10% you are holding back. See, development, testing, debugging, and release. These are 4 milestones, right?
Yeah.
Okay. Now, you mean in equal amount on completion of each milestone. So you mean to say that 50% will be paid in equal amount?
Yeah, 50% will be paid in equal amount.
Okay. I couldn't find this equal earlier. Okay, got it. And then we need provided that 10% will be held back, which is here.
Yeah, that is there on the third point on the payment option and the payment terms. Okay. The third point is that I have written.
So here, then you could have comma except for clause 1.3. You need a connection between 1.1 and 1.3. Okay.
Okay.
Tied it up very neatly, very properly.
Okay.
So which means that 15% will be paid on each milestone, right? If he's saying 60%.
Divided by 4, how much is it's 12.25, I think. 40% first, then 10% is going to be reserved. So balance is 50%. 50% on 4 milestones is 12.25 or 12.5. Sorry.
Right.
12.5. Yeah.
Okay. Because he had said it's 60% of contract value to be divided in milestones of 4.
That's why I said that he should have connected the contract withhold clause with this. Otherwise, it will be that 15, and then 10% hold. So then one gets confused. Then how much do we pay? That's
yeah, right.
Okay. So next assignment for next week is. So before your next week class, you will have all these assignments. Till now, you will have all these templates. Okay. So draft a music license agreement. So there's a singer and director of her own music videos who approaches a video platform for broadcasting videos on the internet to broadcast her videos online. We need to draft specific clauses now. Licensor grants to the licensee a non-exclusive, revocable and limited license over her content. The licensee can use the content to promote herself. Draft a clause which allows for such license grant. So this is a limited license. The licensee can also use this right of hers to separately use her content. Amandeep will have
we have to understand the licensing law and all these things. How do we know that?
In case of a copyright, so you need to see the Copyright Act has one clause which talks about license. It has section 19 capital A. It talks about assignment and licensing. So you can just see that and it'll be enough for you to figure out what to write here. So the question behind point is that we have to see commercial. What is best? When should Amandeep use her rights separately from Zyme Video, and when should Zyme Video have the ability to use this on the broadcasting platform? So it could be that the broadcasting platform has reached in a certain territory or for certain kind of customers, but for other kinds of media, Amandeep Kaur might want to reserve her right to issue separate licenses. Okay. Second is Editorial and creative control is with the singer. She has to provide content to be reviewed so that it may be approved, but she's the one who decides what's there. So draft a clause covering this. Second, Zyme Video has made modifications to her video. Who will own such modifications? Who will own the rights after such modifications are made? This you can design that. You can customize this. You can think commercially what's best. Can Zyme Video make such modifications without prior permission of Amandeep? So this is something that is not legal, but commercially you have to decide this, which is consistent to the fact that she wants to have sole editorial and creative control. At the same time, Zyme Video may want some interest to ensure that they may want to have a right to give feedback and improve these things so that it meets the needs of customers. And
Abhyuday, I'm not able to follow actually which subject you are discussing. Is it the forthcoming assignment?
yes.
Okay.
Then what would be Zyme Video's obligations in this case? Draft the necessary clause encompassing all such obligations. Okay, so this is a clause about the above. What happens in the case when Zyme Video is losing its user base due to which Amandeep's video is not getting enough publicity? Can she terminate the agreement and move on to another online video platform? Draft a clause allowing her to publish her content elsewhere due to Zyme Video not being competitive. That is not producing required results. Okay, now this is uploaded already on your platform. Just let us know in case you have got a different one, because Bhavna said hers is different. Although my idea was that I was under the impression everyone has the same one. Okay, so just let me know. And this is all from me for today. And we'll upload these contracts. So for this one, you will have an opportunity to read it beforehand, even before you submit the draft. Okay. So we are changing the model now so that you are all comfortable with it. But one thing that is going to be there is there's going to be there's already a plagiarism check system which is there on when you upload the software. Now that is going to block your submission if you have more than 30% plagiarism. So why we are doing it here, in future if you want to copy from a contract, you are free to do so. But here, because you are learning it, it makes sense to start drafting your clauses by hand. Once you are comfortable with that, you can do a combination of drafting and copying and using model templates and all of that. Right now, we don't want to start with that, so that you have the opportunity to learn different variations. Okay, so it will block your submission and give you, I think, 48 hours or something to resubmit. Now, if you're writing it on your own by hand, there's a very minuscule chance that there will be plagiarism. So then don't worry, it will not show plagiarism. Okay. So that's the new thing I just wanted to inform you about.